This is WPSL Port St. Lucie, the talk of the Treasure Coast.
You're listening to WSTU Stuart. The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning. This is Stuart Address for Ask a Lawyer. It is July 30th, 2021. We are almost done with the month. And with that, we continue our recent foray into storytelling time. We can call this Storytelling with Stu. How's that sound?
I like it. Yeah, very cool.
And when last we left off, I was previewing the next case I was going to tell you all about. A little bit of a story. And on this one, I don't even have to change the names to protect the innocent. And the reason for that is because it went to trial and to judgment with a jury. And so there is no confidentiality. You can all go find it if you go search hard enough. This is a Family and Medical Leave Act case. And that is coming up a lot more often lately with COVID. We have a lot of people that have to take time off either because they've gotten sick, family members got sick, what have you, one of those things, and they need to take, the Family Medical Leave Act gives you up to 12 weeks of unpaid leave, as long as you have worked for your employer for 1 year and 1,250 hours in the last 52 weeks, which is really, you'll meet that with most part-time and certainly with full-time. And as long as you work for an employer that has at least 50 employees within a 75-mile radius of where you work, not 15 like the discrimination statutes, 50. Congress did not want this to apply to what they viewed as smaller employers. Frankly, I think if you have 40 employees, 30 employees, 20 employees should still apply to you, but only 50 employees within 75-mile radius. And it allows you to take that time off, and the statute allows you to return to the same job you left or a substantially equivalent position. Now that sounds like a lot of legalese. And let me tell you, it is legalese. Because what is substantially equivalent? Well, there are hundreds and hundreds of cases all throughout the country that have opined on what is necessary for one position to be substantially equivalent to another. And so we have a fairly good understanding of it. And essentially it means a job with virtually the same duties, responsibilities, compensation, opportunities for advancement. That is what is substantially equivalent. And if the employer deviates from that, you have a cause of action. And if the employer retaliates against you for either seeking to take FMLA leave or taking it, you have a different cause of action of retaliation against that employer. This is a very employee-friendly statute. It's a federal statute, and it applies throughout the country. The states can't exempt themselves. This is federal law. And it is so employee-friendly that one cannot possibly imagine the current or any recent Congress having enacted it. Why do I say it is that employee friendly? Because it is the only employment statute that I know of, that I've ever heard of, where you don't have to go to your employer and ask for FMLA leave. If your employer knows from you or from gossip or any other way of facts in your life that make the employer think you might be eligible for FMLA leave, the employer has the affirmative duty to give you the federal packet of the application, and then you can choose to do what you want with it. But if you don't know that FMLA exists, doesn't matter. The employer has an obligation to give you the packet if it knows that, oh, you have cancer, or your spouse has cancer, or your child is ill, and you're going to need to take time off. As long as you meet, the 1 year, 1,250 hours, 50 employees within 75 miles, as long as you meet the eligibility, if your employer knows or even thinks it knows of a reason that might make you eligible for FMLA, it has the obligation to tell you, you don't have the obligation to know the statute exists. It's an amazing statute, really.
So dare I even ask which Congress passed that?
I don't know offhand what year that statute was passed, but somehow I don't want to come down hard on the Republicans all the time, because there are some good Republicans and some Republican legislators that I've always admired. There are some that I admire today. I admire Liz Cheney. I admire Adam Kinzinger. I may not agree with any of their policies, but I admire their patriotism. I admire the fact that they truly believe in their oath, that they take an oath to the Constitution, not to their party. And, they've said this too. It's not just me that's saying it. I can't imagine most Republican Congresses or the Republicans in the Senate, if they're the minority party, having allowed this to pass. So it must have been a different era in government.
Well, and I thought they took an oath to their pocketbook.
No, that is precisely what they're not supposed to do, an oath to their pocketbook. No. When we elect somebody, I'm deviating here, but this is a pet peeve of mine. Because there was a time way back when in college where I thought I was going to run for Congress one day. But you are supposed to be willing to sacrifice your job for your principles. Your principles are supposed to take priority. You are supposed to represent your district or your state, but your first obligation is always to your country. This is what defines a patriot from, what some have called, a sunshine fighter. If you shrink in the sunlight, you're not truly a patriot. You're not really brave. It's when it's hard that it counts. Right now, let me tell you something. It's hard for these two congressional Republicans on the January 6th committee. It's really hard. It's so hard that they may lose all their committee assignments. It's so hard that they're going to have primary challengers next year in the election. It's so hard that right now the prognosticators say that Liz Cheney will lose her bid for re-election. She is literally, potentially sacrificing her career in politics, or at least in federal politics, to take the stand that she believes is right constitutionally. And I've got to admire that. And I got to tell you, somebody else who I think would admire that, I think that's John McCain, because I don't think he would do anything other than that.
Well, I'll tell you one thing. I remember Liz Cheney very well when she was on the board at Fox. And Let me tell you, I would not want to go up against her. Believe me.
She does seem quite formidable.
That is the understatement of a lifetime. I think she had the chairman of the board in tears one day.
Well, talking about tears, when I was watching the hearings on Tuesday with the four Capitol and DC police officers that testified before the January 6th committee, when it came time for Adam Kinzinger to ask his questions, he made a statement first. And he visibly was choking back tears in saying thank you to these officers for protecting the Capitol, for protecting the lives of the congressmen and women and senators, for protecting him. You could tell that this was coming from the heart. What he said was not coming from a piece of paper designed for a re-election campaign, I'll tell you. And it made an impression on me. So, with all that being said about how wonderful the FMLA is, let's talk about a case where a bank, let's call it Seacoast, acted in a manner which was in clear violation of the FMLA, at least according to a jury. And this was a case that I had where I'm in my car, I'm on 95, I'm on my way somewhere. I don't know if I was on my way home or on my way to a meeting. And my paralegal calls me and says, I have a PNC, which is our abbreviation for prospective new client. I have a PNC on the phone, and I think she really needs to speak with you right now. Now, that doesn't happen really often. My paralegal is there to basically take the initial screening call, get basic information, talk to me, and then I decide where we go from there. So if my paralegal calls me and says, you need to speak to somebody right now, that's what I have a paralegal for. I'm gonna take his or her advice, and I'm gonna do it. So I have her patch the call through to me while I'm driving, hands-free. And a woman who, I don't know, tells me a story of something that happened that I'm going to tell you about in a moment, and tells me that her bank, her employer, won't give her more than 3 days time off, and she's going to need a lot more. And I hear the story, and I immediately think of the FMLA, and I make sure she's eligible. And then I tell her, send an email to HR. Don't call, send an email. Why, folks? If you've listened to the show, so it's in writing, so that one day if you're in a trial like this one turned out to be, we don't have to argue over what did you tell HR. It is right there in writing. And I told her, send an email to HR that says, I want my FMLA leave. That's it. And then let me know if you have any problems in getting your time off, or if you have any problems in coming back to work.
So you don't have to explain why you want it?
Well, you do, but given the facts that I'm going to explain to you right now, the bank knew why. And so she didn't need to say anything more. The bank, in fact, we sued the bank for a technical violation because they never offered her the paperwork. Remember, you're not supposed to have to say, I want FMLA leave. You don't need to know the statute exists. If the employer, in this situation, the bank, knows that you have a situation that may make you eligible, it is obligated to offer you the paperwork, the forms. And if they don't, that's a technical violation, and there's a cause of action for that in and of itself. So here's the story. She is on her way. She works in a bank, and she's a bank officer that sits at one of those desks, or in the old days, pre-pandemic, sits at one of those desks and handles incoming inquiries and applications. So she's not, I'll say, just a teller, although I don't mean to denigrate tellers, but she's in a higher level position. And she's on her way to work one day and she gets a phone call. And the phone call is from her daughter. And the phone call basically says, "Mom, I'm at the top of the Fort Pierce Bridge and I'm going to jump with the baby." Now, did you folks hear that now? I'm at the top of the Fort Pierce Bridge. I know that bridge. I go over it whenever I go to the St. Lucie courthouse. Okay, in Fort Pierce. And I'm going to jump with this little baby. And she immediately gets on the line with her daughter's psychiatrist. Apparently the daughter had some issues. And the psychiatrist gives her advice, which includes call the police and call DCF. Because if the police are able to save your daughter and that baby, arrangements are going to have to be made. Your daughter's going to be Baker acted, and arrangements are going to need to be made for that baby. And so they'll call DCF, but you should call DCF so that perhaps you and your husband, could take at least temporary custody of the baby instead of it having to go into the system and then being given to you. If I had a call like that, folks, I don't think I would be able to drive.
No kidding. That's brutal.
That is brutal. And so she is still on the phone with the psychiatrist. She's already called her husband, who works in Jupiter, so it's further away, and told him what's going on. And the husband is assuming that she, up here very close, is going to be the one to rush to the bridge with the police. And so he's staying put for now at work. And that makes sense. And she walks into the bank while still on the phone with the psychiatrist. And she goes directly into the office of the assistant manager of the bank. Manager's not there. It's opening time. The bank's not open yet. She walks in, and she goes directly to the assistant manager's office. And while still on the phone with the psychiatrist, with the phone to her ear, she tells the assistant manager, "I have to leave. My daughter is threatening to jump off the Fort Pierce Bridge with my brand new grandson." And what does the assistant manager say? "You can't leave." Why? Because federal law requires that a bank have a certain number of employees present to open the bank. That's why so many banks are still closed with the pandemic. They don't have the staff. But anyway, this was pre-pandemic, and you can't leave because then we won't have enough people here. You can leave in a few hours when we have appropriate staffing. Oh, and by the way, I'm leaving. I'll be back in a little bit. Now, where is she going, folks? She's going to pick up T-shirts for a charity event that weekend. So you might wonder, as I eventually did, why can't she pick up the T-shirts a little bit later and let this poor woman rush to the aid of her daughter and grandson? Oh, I sure asked that question in trial. I badgered the heck out of her over that.
Yeah,
one.
T-shirt places are usually open to 6 o'clock.
That's right. All right. So the assistant manager says no. That's also a violation of the FMLA. And what does my client do? She has a choice now. And a lot of people have told me they would have made a different choice. And I disagree with them. But she has a choice. Stay, as she's been told, for a couple hours perhaps, and then leave. Or leave right now and lose her job. She is concerned that if she leaves right now and loses her job, and she and her husband need to take care of the baby, she needs the income. And so she doesn't feel capable of leaving. Instead, she calls her husband again and says, you need to leave. You need to rush to the bridge, and you need to deal with the police and DCF until I can. Now, remember, it's going to take him much longer to get there. By the time he gets there, this could all be over with and done with a very, very bad result. It would have been much better if she could have got there in 15, 20 minutes. But she's told, you cannot leave. So she doesn't. She leaves when she's allowed to leave. They save the daughter and the baby. Otherwise, I wouldn't be telling you this story. The daughter is Baker acted, and the baby does go temporarily into the custody of my client, my eventual client, and her husband, because they had coordinated it very well. And then I get the phone call. You know, she asked for time off to take care of the grandchild and to take care of her daughter, who presumably will be out very soon and will need to go to psychiatrist visits and what have you. And she's told she can have 3 days off. Very generous. This woman doesn't know about the FMLA. She's upset that she can only get 3 days off. And she does the thing I tell you all to do. She asks a lawyer. And this is when I get that phone call. And I tell her, just send an email to HR and say FMLA. You're not supposed to have to do that, but do it, and let's see if they change their tune. And she does. And they immediately give her the paperwork, and she gets her 12 weeks off. Doesn't need me. Until she's ready to return now, because you can only have the 12 weeks. And things have been set up, and things are back into a pattern of life. And she's ready to return. And she lets the bank know. And she comes back, and they put her in a teller position. Now, nothing wrong with being a teller, but the pay is less. The opportunity for commissions is much less. The position does not have the same or similar duties, responsibility, authority, opportunity for advancement. It is not, in my view, a substantially similar position. And she calls us again, complaining about how she's being treated now that she returned. It's as if she says, they're punishing me for taking the FMLA leave. That's indeed what they were doing. They were trying to do it in a sneaky way. They didn't fire her, say you can't come back. They just gave her another job that wasn't going to be as pleasurable or profitable. And she, of course, takes the position because it's better to take it and talk to a lawyer than to say no and have unemployment. And we write, a demand letter. It doesn't get us anywhere. And we hold a press conference. Covered on TV. I still have the video. And we file a federal lawsuit. for violation of the FMLA. And actually, it's for 3 violations. 1, not giving her the paperwork when the bank had reason to know that she was entitled or may be entitled to FMLA leave. 2, for retaliating against her for taking the FMLA leave. 3, for retaliating against her by giving her a position which was not identical or substantially similar, and then concocting a set of circumstances, we alleged, which led to them terminating her. So,
I got a question. What if they
Sure.
moved her into a teller position, but kept her salary that she had in the other position?
well, they tried that after they gave her the lower pay and she complained. They did give her back her prior pay, but now she wasn't getting the same opportunity for commissions, and she didn't have the same duties and responsibilities regardless of the pay. So, good question, though. I'm sure that's a question that they had on the jury, and we tried to answer that, figuring that would come up. And what happens? She's now in a teller position. What happens that leads to her being terminated within 3 weeks of returning to work? 3 weeks. That said to me, they planned this. And you want to know something? I found a case during my research. I didn't know this off the top of my head. This is what lawyers do. They research. I found a case that applied in Florida that says that there is a presumption that there is a causal connection between a retaliatory act if it occurs within 30 days of the act which led to the retaliation. So she returns to work and now is terminated within 30 days. I'm entitled to at least an inference being told to the jury to presume there is retaliation. And lawyers love inferences and presumptions.
See, they should have waited 31 days.
Well, and then they wouldn't have had an inference, but I still would have had to prove, by a preponderance of the evidence that this was a sham. But at least now I'm starting, it's like in the Olympics saying in the 100-yard dash, you can start 5 yards ahead. That's what an inference is. Doesn't mean I'm going to win, but it means I have an advantage.
It worked for Rosie Ruiz.
That's right. Jump in the middle of the marathon. So what happens? She's there as the teller, and all of a sudden she starts being written up. Now, mind you, she'd worked for the bank for years, had never been written up. But all of a sudden she returns to work, and she's being written up on, every couple of days. It's an amazing coincidence, don't you folks think? That's the kind of juror I would be looking for, kind of jurors who would say, that's an amazing coincidence. And I don't buy it for a second. Don't try to sell me the Brooklyn Bridge. And what is she being written up for? Her teller drawer is off by a few dollars here, a few cents there. And sure enough, in the employee handbook, it says tellers, may be written up if their drawers do not balance. I'm holding back a piece of what's in that handbook, though, folks. I want to be honest with you. I'm saving it for later. So don't leave your radio. And if you do want to call, it's 772-340-1590. And so she's written up, and ultimately she's written up enough times that under the employee handbook, they're allowed to terminate her, and they terminate her. And, it works its way into the lawsuit as a cause of action. And so we do all this discovery, you know? What is discovery? It's a year or more of, tiresome battles back and forth between the lawyers. What will they give me? What won't they give me? What do I have to tell the judge they won't give me, and have the judge decide, am I entitled to it? Depositions, trying to prove that people are lying to me under oath. And people say, do people really lie under oath at depositions? Every dang friggin' day and hour. How do I know they're lying to me? Their mouth is moving. It happens all the time. Part of a lawyer's job is to gather enough information before taking a deposition, if possible, to know when they're lying to you and to be able to prove it. That's the art of cross-examination. So, in this particular situation, we figured current employees of the bank are going to toe the company line in terms of the story they tell. And we have to be prepared for that. Very often there are some heroes like Liz Cheney and Adam Kinzinger, but others are going to tell the story the bank wants them to tell because they don't want to lose their job. So how do we, disprove it? Well, when an employee says she was free to leave whenever she wanted, and you have 4 other employees saying the same thing, that were working there, before she left, they can't come into work. How do we disprove that? Well, we might be able to disprove it if we find something concrete, like they told another employee, I can't believe she can't leave, and that other person testifies. Oh, that would be great. But if you can't find direct evidence, you settle for what you can in terms of trying to persuade a jury not to find this person to be a credible witness. And if you can find a lie somewhere else, you find the lie somewhere else and you use it to impeach their credibility. So here, I had a paralegal, and I will give her credit. It's my ex-wife, Aaron's mother, who, oh my God, I can't believe I'm saying this on the radio. I'm going to have to send this to her on tape because, she was an incredible paralegal, extraordinarily skilled. So good that when I took her to a trial or I took her to meetings with other lawyers, she had the freedom, not just as my wife, but as my paralegal, to speak without running it through me first. To interrupt a lawyer and ask a question instead of just passing me a note. And at trial, okay, she has to pass me a note. She's not allowed to speak because she's not a lawyer. But, she had a lot more power than other paralegals. They even noticed it. At trial, we had a 2-week trial. And the bank brought like 3 or 4 paralegals with computers. She later found out those paralegals weren't doing anything. They were just there for show. And they couldn't believe the power that she had to nudge me, to pass me notes, to force me to listen to her. To them, that was, wow, paralegal with power. They could only dream of it. Anyway, so she dug up something that I now look for regularly, but back then I had never even heard of such a thing. She checked the Facebook profiles of each employee witness that we were going to depose to find out what she could about them.
Oops.
In case there was something that might be helpful. And what did she find with respect to, I would say, most of the employees that we were going to depose and might be bank witnesses against us or against our client? What did she find? She found an amazing frequency of virtually all these employees playing the game Farmville during working hours, which meant they were using their computers at the bank on their downtime to play Farmville.
Oh, come on.
Oh no, this was it a lot. So, I had that little tidbit of information, and she gave me the proof for each witness as we were going to depose them, all the times and dates, the screenshots. And, I didn't know if I'd ever be able to use it. I didn't know how I was going to use it. I just knew I had information. And as I'm deposing witnesses, and I know they're lying to me because the stories are just absolutely contorted to the bank's favor and against my client, I decide I'm going to impeach their credibility and hope to use it later on at trial. And let's see at deposition, which is where you do this. Am I successful in the effort? So during hours of deposition, I get to a point where I just, seemingly I'm not at any special point of the deposition. It's not like they had just lied to me or something. An hour later. And I said, what are the rules about, your use of the computers at work? Let's say if you have some free time or, things aren't busy. And I get them to tell me in their own words what, HR's policy is and what's in the handbook. And of course they tell me, you're not allowed to use the bank's computers for personal things. Can't do. Oh, we do have a call, so hold that thought and let's talk to Pat on line 1. Hello, Pat.
How you doing?
I'm doing fine. What do you have to ask me or to talk about?
Okay, I have a couple questions and then I'll listen off air.
All right, sounds wonderful.
Number one, please tell me what you think of Biden in his first 6 months.
Okay.
And how many immigrants have died in the first 6 months? And how many immigrants died in the first 6 months of Trump? Thank you.
Okay, he wants me to answer 2 questions, and he's going to listen offline, and I will do my best to answer them honestly. What do I think of Biden's first 6 months? Overall, I think he's had an excellent first 6 months. Has he done everything that I would have liked him to do? No. Has he done everything that he has tried to do well? No. Has he had missteps? Yep. Do I think that perhaps he should have given up these efforts at getting Republicans to come along and learn the lesson that Obama took so long to learn, which was if they're not going to cooperate, do it on your own? Yeah, I think Biden, after 8 years with Obama, should have understood that when Republicans were fighting so hard, he should have done what he could with the Democrats. I think his heart has been in the right place. And I think he has a very evident connection with voters when he meets them. And I think his sincerity is on the scale of 120 of 100. You can't find somebody who cares more about people. Doesn't mean he's always right and doesn't mean he's always effective. Immigrants dying. Okay, I know where the caller is going. I guess on a numerical scale, perhaps more immigrants have died in the first 6 months under Biden than did under Trump. I won't be callous in terms of anybody who's died and say, so what? But I will say that doesn't really mean all that much unless you put it into context. Now, I don't have that information and I don't know the story, but I suspect I know where the caller was going. So I'm going to submit that the situation is dramatically different, that a lot more immigrants are crossing borders, which means a lot more are going to die. And those that have died in federal custody, which is a travesty at all, I know from what I've heard that Biden is working on that. And I also know that He didn't build the cages, Trump did. And he's tried to dismantle the cages. But that doesn't mean that some of the conditions that people are held in don't look like cages. Even if they're just behind bars, it looks like a cage. So that's my impression on that. Okay. But thank you for the call. I really, and I hope at least if you don't agree with me, I hope you at least believe I tried to give you an honest answer. So now I have this information. I say, well, so you're not supposed to use the computer? Is that like at all, or are there exceptions? No, we're not supposed to use it at all. You know, the idea is to get these witnesses now to tell me a story and tell it to me a second time and a third time. So there is no chance at trial that they could say they misunderstood me, they got it wrong, they didn't recollect properly. You lock them in solid before you try to bring down the hammer. So I locked them into this story about the bank's policy and the possibility for termination. And then once that was locked in, I go and let's say, like, for example, are you allowed to be on Facebook? Oh, no, absolutely not. To a witness, they all said that. Oh, no, absolutely not. Lock it in twice, 3 times. Ask the question different ways. Lock that in solid. And then sort of like out of nowhere, like it's not planned. Well, and like, would that include things like, I don't know, Farmville? Oh yes, no, we can't play Farmville, you know, during working hours using the bank's computers. Okay. Lock that in. As they say, lock in your answer? Okay. So now we've locked all that in. And I locked that in with each of these bank witnesses. You know, each of the branch witnesses, let's say, because, you know, I didn't lock that in when I'm talking to the HR director, executive vice president of Seacoast Bank. That's not the person you do that with. You get him to confirm that they're not allowed to use the bank's computers, and you get him to confirm all this stuff, but you know, you're not challenging him like he did it. And so now let's say we're done with discovery, and now it's trial time. And, you know, before we actually talk about the trial, let me tell you about voir dire. We talked about this a little last week in a different trial, the one with the teenagers that all lied, and all of a sudden the second day of trial, I'm told by the attorney I was working with, I'm going to be in the Keys. You handle voir dire. Thank you. Well, this was my trial alone, so yes, this trial I was handling voir dire. And, or as they say a little bit further south, voir dire or voir dire. But no, it's voir dire, at least the way I say it. And, you know, the difference in federal court and state court with voir dire, in state court, while the judge has the right to cut you off whenever the judge believes is appropriate, the judge tends to let voir dire go for a day or two in any case. Federal court? First of all, you're lucky if you get to address the jury. The judge does it. The judge allows you to submit to his honor, propose questions that you would like him to ask the prospective jurors to help you make your decisions as to whether to challenge them for cause, bias, or to use a peremptory challenge, one of a limited number you get, on them if you don't think they're going to be fair, or you think they're going to be fairer to the other side. And you're allowed to file a motion with the judge to ask for a certain amount of time for you to be able to address the jury and ask questions. Well, federal judges receiving a lifetime appointment are God in their courtrooms, literally. You know, you can't run up on appeal, at least not right in away, because the judge wouldn't let you do voir dire, or because the judge wouldn't ask a question you wanted asked. Oh, if you lose the case and you're taking it up on appeal for some other reason, you can throw all this stuff in there. But most of the times it doesn't happen that way. And so this particular judge would not let either attorney address the jury and ask a single question, did not ask any of the questions that either attorney proposed, and did the entire voir dire in about 20 minutes. What I call a drive-by voir dire. And to show you how dangerous that is, how reckless that is of a federal judge, the first day of trial, the first two witnesses that we called, the judge had to excuse one of the jurors. So 2 jurors. We had 8, 6 and 2 alternates. Now we have 6, the minimum number. And if we lose another juror, it's a mistrial. Now, why did we lose 2 jurors so quickly? Well, because in the judge's voir dire, the judge neglected to ask a very basic question. Do any of you know any of the parties, any of the attorneys, or any of these people who are expected to testify during this trial? So when witness number 1 is called, a bank witness, I called, and all of a sudden we're questioning this witness, I don't know for how long, and all of a sudden a note gets passed from a juror to the U.S. Marshal that is serving as a bailiff inside the courtroom. And the marshal hands it up to the clerk, and the clerk hands it up to the judge. And the judge says, we're going to have a conversation with the attorneys. The jury is dismissed, go to their jury room. Counsel approach the bench. And the judge says, well, counsel, this particular juror, they know the husband of this witness, and they have been friends for many, many, I've been told, I am not even halfway through this trial, and I'm being told I have 5 minutes. Oh my goodness. Well, this trial will be continued next week. And they can't possibly be fair because they're going to believe whatever this witness says. Goodbye, Mr. Juror. That's down now to 7. Next witness, a problem, not the same problem, but something about a law enforcement officer and a conflict. And oh no, I'm sorry, I misremember. All of a sudden we're told that if this trial goes more than 1 week, that juror has cruise tickets that have already been paid for. Goodbye, you're excused. And the judge says to us at the bench, if we lose, I make this argument to the judge because I'm really angry about the judge's voir dire. And this is why we've now lost 2 jurors. And the judge says, well, I'm making this argument. What if we lose another one? It's a mistrial. Judge says, no, not really. You lose another one, you can both agree to proceed with 5. No. That was how callous that judge was about this, or cavalier. So we have our 6 jurors, and we better not lose any more. And I start to question bank employees. And let's just, to end today's session, tell you in a generic overview, each one of these people are segregated. In other words, they don't hear each other's testimony. They each tell me the same lie. They repeat the lie from deposition. And I confirm with them that they told me this at deposition. And they lie about, playing games in Facebook and Farmville. They knew I knew because I had asked them about it at deposition. Yet they lie to me in court anyway. So isn't it true that at deposition at page 37, line 15 to 22, you testified as follows? And they each say, well, I don't remember. I said, well, here's the transcript. Do you disagree that this is what you said? Well, I don't know what I said. Do you believe the court reporter typed it wrong? Well, I don't know. Are you really telling me you don't believe you said this? So this is what we're having to do now with them. I asked the judge for permission to declare the witness a hostile witness. Denied. However, and the judge kept denying those requests when I was asking bank people. But what the judge began to do more and more was, while he wouldn't declare the witness a hostile witness, he allowed me to argue with them, and would overrule the bank counsel's objection to that I was badgering them.
But you had pictures, right?
Yeah, but now I'm talking about leading them as an adverse witness, the hostile witness. So once I saw the judge was going to let me get away with this, even though he wouldn't declare them a hostile witness, I started to badger them even more. And once bank counsel saw that he was going to overrule their objections and he doesn't want to look like he's trying to hide something in front of this jury, I took even more license. And I really would badger them like crazy, knowing that the judge was going to let me get away with it. And the bank attorney would stop objecting because he didn't want to look like a check in the box. And boy, I was able to have a lot of fun with these people. And on that, we will tell you more next week. And I am going to wish you a good week and a good weekend and tell you I'm starting a lovely vacation, my first one in over a year and a half, tomorrow, going up to Orlando with family. How many family fights we get into, I don't know. But I'll be back next Friday, presuming they don't kill me. And we'll continue with another edition of Ask a Lawyer. Thanks for listening and hope you enjoyed it and hope you come back for the conclusion of the FMLA trial. Take care. This is Stuart Adgis for Ask a Lawyer.
Ask a Lawyer, the rest of the story next week on WPSL Port St. Lucie at WSTU.
Where have I heard that before?
Yeah, I think I've heard that somewhere.